Welcome to another episode of the Unplugged Divorce Attorney. Today, I'm going to talk about our friends over in Arkansas. They passed a bill in 2021 that changed child custody cases in Arkansas. Basically, the bill sets out a rebuttable presumption of joint custody in child custody cases. And this rebuttable presumption can be proven by what's known as clear and convincing evidence that joint custody is not in the child's best interest. It's right here in the statute. So, what is clear and convincing evidence? Somebody asked me, give me an example of clear and convincing evidence that would prove to a court that joint custody is not in the child's best interest. Well, here's one thing I can think of right off the top of my head. If the other parent of the child gets a DUI, especially with the child in the car, game over. Game over. It's probably going to convince a court, probably not a good idea to let that parent be driving the kid around, all right? This is a great new emerging area of child custody law where a state enacts a statute that says default, we're going to go to joint custody. Now, there's nothing in the statute itself, the new statute, that defines what joint custody is. It could be 3 days with dad, 4 days with mom, or vice versa. It doesn't say anything else. It just says joint custody. And is that legal custody? How is that defined? Is it the choice where the kid goes to school, or the religion or medical decisions? Is it all decisions affecting everything about the child's life? Or is it just where the child sleeps at night? So here's the point of the video. Go down the rabbit hole. The folks in Arkansas have said, look, we're going to go off the bat by the statute, joint custody. So if you think you're going to get sole custody, you better give the court clear and convincing evidence, which is where a lot of people get tripped up because a lot of non-lawyers don't understand the rules of evidence. And they think that they could just bring in any piece of paper and not authenticate it properly and think that the court has to take it into consideration. Wrong. Get good counsel on your side. They'll know the rules of evidence, and they'll be able to navigate the court system, and they know the burden of proof and how to reach that burden, okay? This is the Unplugged Divorce Attorney. Like, comment, if there's something you want me to talk about. We've got some great topics coming in. Subscribe. The channel's just getting started. Be careful out there.